Hello and welcome. The political power tussle in Rivers State has taken yet another twist as the Court of Appeal sitting in Abuja has nullified the decision of the Rivers State High Court, which stopped the Speaker of the State House of Assembly, Martin Amaewhule, and 24 other of his colleagues from parading themselves as members of the House. The Rivers State High Court had said the 25 members had lost their seats for defecting from the PDP to the APC. The State High Court made the ruling, by way of ex parte order. But the three-member panel now of the appellate court has now held that the Rivers State High Court lacked the jurisdiction to grant that ex parte order. The appeal court held that Section 272, subsection 3 of the Constitution gives the Federal High Court powers to determine whether the seat of a House of Assembly member has become vacant, adding that the Federal High Court has the exclusive jurisdiction to determine if the seats have become vacant and not the state high courts. It therefore voided the action of the Rivers State High Court, effectively returning the 25 members to the State Assembly and Martin Amaewhule as the Speaker. Before now, Victor Okojumbo had been parading himself as Speaker, leading two other members of the House who are loyal to the governor of the state. Let's discuss the implications of this latest ruling now. Joining me on the show is Libros Oshoma, who is a legal practitioner and political affairs analyst. Also joining me on the program is Douglas Ogbankpa, who is also a legal practitioner. Gentlemen, thank you very much for coming on the program. Libros, let me start with you. Is this a surprise in any way at all? Does this ruling by the Court of Appeal come to you as any surprise?
Deji, yeah, thank you for having me on the program. And remember the last time we discussed this matter, I told you that clearly that what the Jumbo faction did was to hide under the fundamental right enforcement procedure to ask the court to determine the tenure of members by saying that his right as a speaker is about to be threatened. And I also said that the High Court of the Rivers State High Court clearly lacks jurisdiction. And so I'm not surprised by this ruling of the Court of Appeal. And quickly, so that I yield the floor for my colleague and brother, I want to quickly draw attention. Section 251 of the Constitution vests jurisdiction on the Federal High Court. It says, subject, notwithstanding anything to the contrary contained in this Constitution, and in addition to other jurisdiction has been conferred upon it by the Act of the National Assembly, the Federal High Court shall have and exercise jurisdiction to the exclusion of any other court in civil matters and causes are not listed. And so if you go to that Section 272, subsection 3, it was the first alteration number 28 of 2010. It says that subsection was added to Section 272. It says, subject to the provision of Section 251 that I read just now, and other provision of this Constitution, the Federal High Court shall have jurisdiction to hear and determine the question as to whether the term of office of a member of a state House of Assembly of a state, a governor or deputy governor, has ceased or become vacant. So what the court simply said is, that the State High Court lacks jurisdiction to hear and determine questions on the vacancy of members of a State House of Assembly or governor or deputy governor. And also the court went further to say that even that order, granting an ex parte order in itself, was an aberration. That was a denial of fair hearing. And I also think that it was so because, remember, long ago, Justice Kayode Esho of blessed memory had warned state high courts or high courts generally to mind the way they grant ex parte order. And so determining the rights via ex parte order, according to the Court of Appeal, was a denial of fair hearing. And at least he ought to have allowed the other party, he ought to have heard the side of the other party. And I completely agree with the position of the Court of Appeal.
Douglas, let me get your own take on this, because, before now, one would have thought, well, since we're talking about the Federal High Court shares the same jurisdiction as a state high court. I mean, they are courts of coordinate jurisdiction. So why would then why would the Federal High Court now have exclusive jurisdiction to hear, matters of this nature?
Okay, now, you see, the people who drafted the 1999 Constitution actually conferred jurisdiction as of 1999 on the State High Court. However, at about 2017, the National Assembly did the alteration, which is the fourth alteration, that now provides that Federal High Court would have exclusive jurisdiction over matters that pertain to whether the seat of a member of a House of Assembly is vacant. And this is flowing from the abuse of the jurisdiction given to the State High Courts. As we know, these governors actually have a lot of control over the State High Courts. And Nigerians tend to pretend that that's not the case. And that is why you see that the River State cases are going the way they are going. And you would see that the Court of Appeal had to intervene. This is something that is written in our laws. However, you find that state high courts continue to hijack jurisdiction, if I would say, and it's actually a despicable situation. And the only way we can stop such very, very ludicrous judgments, coming as party to be done, is for us to ensure that those judges that gave these very perverse judgments are made to face the wrath of the National Judicial Council. Continue like this. When governors wake up and they will determine how judgments are given in this country, we must, and I must insist, we must ensure that these judges, once the Supreme Court affirms that they lack jurisdiction in the first place, the hammer must fall on them. And you must also realize that this scenario where you find like some states where the governors have taken over the House of Assembly, and the cases even went to the State High Court. You find that those cases have not seen the light of day. I know a particular case, I will not mention the state, that the case has been in the State High Court for about 4 years. And my brothers, I'm talking to you now, nothing has gone on in that case. So I want to thank the Court of Appeal for saving Nigeria from the clutches of these governors who they think that they are God, but they are governors. Their powers are provided for by the law. They are not to act as emperors. And I am happy and very elated that the judiciary has made us proud today. I am happy that the judiciary has affirmed and reaffirmed sections 251 and section 272 of the Constitution for the avoidance of doubt. May I explicitly state, without any equivocation, that section 272 of the Constitution stipulated in subsection 3 that subject to the provisions of section 251, that is the conferring section, and other provisions of this Constitution, the Federal High Court shall have jurisdiction to determine the question as to whether the term of office of a member of the House of Assembly of the State, a governor or deputy governor, has ceased or become vacant.
But let me ask you, Douglas, does it mean these judges at the state level, like the judge who issued this ex parte order, does it mean he doesn't understand the Constitution or doesn't know this and didn't know that he didn't have the jurisdiction in the first place?
Judges to take a right. Take this particular judge who assumed jurisdiction, knowing that he had no jurisdiction in the first place, to face the wrath of the National Judicial Council. Enough is enough. Enough is enough in this country. We will not allow some persons to desecrate our Constitution. The Constitution of Nigeria is abandoned. I run the vanguard of the judiciary, and I stand here to say that some of us are very passionate about these matters. You have a scenario where a high court in Kebbi will go and assume jurisdiction over an election in Anambra, and nothing has happened to that high court judge. We will not continue like this. The judge knew he had no jurisdiction. As a matter of fact, they filed before that court a notice of perennial objection and abated the mind of the judge to that section. And he still went ahead to give a judgment that affects the over how many million people in the River States. This is unacceptable, and we must call this spade a spade. We must stop all this trying to paint things as if we are padding things. What is wrong is wrong. If the Supreme Court affirms the judgment, you should face the wrath of the law. That is my take on it.
All right, Libros, let me quickly come to you. Help us understand what then is the implication of this judgment. Does it clearly, no doubt, that it reverses everything? So Amewule is now speaker. Oko Jumbo, who was leading a three-member house, of course, ceases to be speaker.
You see, DG, we had argued this matter back and forth. Some persons have argued that the provisions of this constitution, some of these provisions, that declaration of the seats of members who defected are self-executory. While some of us have argued also that no, it is not self-executory.
And from the latest judgment of the appeal court, it's clear that it's not self-executory.
Yes, it is not. If you look at, the determination of a vacant seat means that the court can be invited. And also, if you look at the provisions of the law, it is the speaker that can declare such seats vacant. The question now would be, who was the speaker as at that time that these members allegedly, purportedly, were said to have defected? So these are the questions that the law would determine. But this idea of, now trying to, hoodwink and bandy everybody, and no, once they move, their seat is automatically vacant. Somebody must make that pronouncement. That is the position of the Constitution. That pronouncement must be made. And so, when a pronouncement has not been made, it is not in the mouth of the man on the street to now come and say, oh, look, that because somebody has defected or that somebody in the house had said so. So these are the challenges that we have consistently faced in our laws. And it is also, the onus is on us as a people to allow the courts to take, decisions when the matter are submitted to the jurisdiction of the court. And I also support, quickly, I want to say that to support the position of Douglas, the state he has refused to mention, and for reasons best known to us, I know why, is the state he is in, the state we both come from, Edo State. Members of the State House of Assembly who were refused inauguration. The matter was instituted at the High Court in Edo State. That matter in 4 years was passed from one judge to another for 9 judges. And not for one day was that matter, mentioned. And so, you now begin to ask, not for one day was the matter mentioned. And so you now begin to ask yourself, if the powers of the State House of Assemblies, the State High Court have been hijacked by state governors, and the same way the powers of State House of Assembly have been hijacked by sitting governor, then we consistently complain about, the federal government having too much powers. And the state high courts and the State House of Assemblies have relegated or delegated their responsibilities and their powers to the governors. It means we are continually burdening the federal high court and the federal government with more powers. And quickly, I was looking to draw your mind again. I was looking at section 68, subsection 1, paragraph G. It says, being a person whose election to the House was sponsored by a political party become a member of another political party before the expiration of the period for which that House was elected, provided, there's a proviso to that section, provided that his membership of the latter political party is not as a result of a division in his party. This proviso gives powers for explanation. And so it is not self-executory. And who determines this explanation of, we have a coalition of political parties, or this is the reason why I defected? It is the court. And before now, the State High Court had been doing it. And because the governors have hijacked the powers of the State High Court and abused it, the National Assembly in its wisdom now decide to domicile that powers exclusively in the Federal High Court. This is the same thing that we have been complaining about. No, let us relinquish powers or delegate powers to the state. But you delegate these same powers to the state, they are abused by one man who had turned himself to an emperor, a state governor. They are abused by the governor. And so now we take it back to the federal government. So the question, now to answer your question directly, with the judgment of the court now has removed that impediment that says these persons are no longer members. The court has said, in the first place, you have no jurisdiction to make that pronouncement. So what has happened now is that the court has returned parties to status quo. Martin Amehule remains the speaker, and then the 24, 27 lawmakers also remains lawmakers. Deji, it's an aberration that, contrary to Section 91 of the Constitution, that 3 members will sit and say they are members of the House of Assembly and elect a speaker among 3 members and pass a budget and screen commissioners and screen members of local government caretaker committees, and then we clap for them. We abuse the Constitution daily because when it suits some people, they clap. When it doesn't, and then they tell you, no, it doesn't matter. We can't build a country this way.
All right, I just want us to take a short break. We're going to come back, and this time we'll be discussing, well, incidentally, political developments in your state. So stay with us, don't go away. Hold on. Welcome back. Let's go to Edo State now, where Justice Inyang Ekpo of the Federal High Court in Abuja has declared invalid the People's Democratic primary election that produced Asue Ighodalo as its governorship candidate. The election conducted on February the 22nd, 2024 was voided on the grounds that 378 delegates who were supposed to vote at the primary election were unlawfully excluded by the PDP. Justice Ekpo nullified the primary election while delivering judgment in a suit instituted by the aggrieved delegates. The suit was actually instituted by one Kelvin Mohammed in a representative capacity. Now, Justice Ekpo held that both the provisions of the Electoral Act 2022 and the PDP guidelines were violated in the conduct of the primary election at the Samuel Igbomodia Stadium in Benin City. Justice Ekpo also said that Exhibit PDP-1 tendered by the party was bereft of evidence, and also held that the plaintiffs, through the exhibits tendered, were able to establish their case against the defendants. The judge said from the exhibit presented by the PDP, he found that the returning officers who prepared the result sheets were only sat down actually in a place to manufacture the outcome of the poll. He said the exclusion of these 378 delegates, including the plaintiffs, was against the provisions of the law. Justice Ekpo held that though the Independent National Electoral Commission, INEC, that's the first defendant now, filed a memorandum of appearance in the suit, it was unfortunate that the commission did not file any process in the case. According to the judge, the first defendant's counsel only said it would be bound by the decision of the court. So he went on to say, I found that the case of the plaintiffs succeeds on merit, quote and unquote. So the 3 aggrieved ad hoc delegates on behalf of the 378 others had sued INEC, the PDP, its national secretary, and the vice chairman, South-South, as first to 4 defendants respectively. In the suit, the plaintiffs sought 2 orders. This include an order for the defendants or their agents not to act, but to show cause why the reliefs of the plaintiffs in their originating summons should not be granted concerning the plan of the 2nd, 3rd, and 4th defendants to exclude them and 378 other delegates whose names and election results were contained in Exhibit Bid 8A to 8L from participating in the primaries of February 22nd in Edo. Well, that's what it is, and effectively, what this means is that Asue Ighodalo's candidacy has now been invalidated. But let me just get the reaction now. Let me start with you, Douglas. Does this effectively means the invalidation of Asue Ighodalo's candidacy, of course, until he appeals and then gets judgment in his favor?
As today, the only judgment of court known to law is the one you just summarized. And so, one, PDP does not have a candidate for the September 21 Edo State governorship elections, and Asue Ighodalo is not a candidate for the elections. So it's actually one of the things that we talk about of the impunity that pervades our system. And it is the court found cogent, compelling, and incontrovertible evidence to show that 378 ad hoc delegates were unlawfully excluded from the primaries, including the three claimants and Kelvin Mohammed himself. So I think the Nigerian judiciary is beginning to really get my vibes. I'm beginning to like the Nigerian judiciary. These are the kind of judgments that would, I will be happy to read this judgment to my children, who I'm sure will study law. So I feel like we should stop all these things like nothing they happen. You do whatever you like. So much impunity, so much non-adherence to due process. And when the judgment comes, you start speaking too much grammar. The judgment is in conformity with the law. It is obvious that the PDP guidelines were breached. As a matter of fact, Exhibit PDP 1, which expressly shows that indeed the case of the claimant, Exhibit PDP 1 seems to be a confirmation of the case of the claimant. And of course, it is obvious that the Federal High Court has done the right thing by actually invalidating the primaries held on the 22nd of April, 2024.
Let me get your take on this.
Deji, you see, when these primaries were held, and the desperation of Governor Obaseki to impose a successor, some of us from concerned citizens from the state did raise an alarm that, yes, in as much as you would want to have a successor, but there are procedures that must be followed. APC also almost made the same mistake. I remember also granting an interview, and I intervened and I said that if APC continued the way they were going, they might end up not having a candidate, just like PDP. Because the Supreme Court had laid a foundation. You remember the case of Rivers. It's still fresh in our memories. Some supporters of Magnus Abe then went to court that they were wrongly excluded from not just primaries, from the congresses that produce the leaders that eventually nominated candidates for primaries. And the court gave an order that parties should maintain status quo. But they went ahead and nominated candidates for the election. And the court invalidated the entire processes. That the fact that these claimants were excluded after duly paying, the required fee, contrary to the provisions of the constitution of the APC then, and that the process was invalidated. In the same vein, to borrow the language of my learned friend and brother, Obayagbon, he constantly pursue the PDP in Edo State, wanting to do the bidding of one man. And because also he wanted to exclude Philip Shaibu and his delegates at that time, forgetting that all of these supporters of Philip Shaibu were ad hoc delegates for the primaries. They were excluded. They were locked out of Samuel Gbogbondia Stadium. And so some of them now had approached the court to say the fact that they were excluded from the process of determining who becomes a candidate in the process, that process should be invalidated. And it is too late in the day now to ask them to go back and redo it.
Why is it too late? Why is it too late?
The time for nomination of candidate had lapsed. So the only reason that the primaries of Philip Shaibu was not upheld by the court was the fact that the venue where that primaries was conducted was not the venue for the primaries. So you have two wrongs here. The candidates were wrongly excluded. They went to another venue and conducted a sham primary, which the court did not recognize. But the court also recognized the fact that they were excluded from the process. So that exclusion robs the entire process of its validity. That's what the court is saying. And so, if this position continued to the Supreme Court, PDP and Governor Baseki's desperation, which I warned them of, my videos are still there, and I did warn them that excluding Philip Shaibu, who has been with him, will spell a doom for them in the election. And they went ahead. They did all the abracadabra they needed to do. They called me names. But today, the Court of First Instance had taken the first bite. We'll wait for the Court of Appeal. And the way it is going, I can tell you,
it will definitely get to the Supreme Court.
It will get to the Supreme Court, and PDP in Edo State might end up not having a candidate in the election. Just like it happened in Rivers, it happened in Zamfara. It also happened in Bayelsa. Bayesa's own was on grounds of disqualification of the running mates. So in this case, it is the process that produced the candidature. So there's nothing anybody can do about it. It's a shame. But this will serve as a lesson to desperate governors who are desperate to impose candidates, who are desperate to hoodwink and blackmail and force their way through a political party. And the court will consistently come to the rescue of some aggrieved spoilers, or maybe they'll use the word.
All right, we'll wait and see how the appeal goes, because obviously the PDP will appeal this, and it's given that indication that it's going to do that. Gentlemen, I want to thank you very much for coming on the program. Thanks a lot for your time. And that's how much we can take on the program. Thank you very much for watching. I'll see you again next time. Bye-bye.